After 2 years of hard-fought litigation, your attorney finally comes to you and says that the defense has started to negotiate. They have now offered $2 million to settle your case. And you're thinking, what took them so long? They should have made this offer years earlier. Shortly after you started your lawsuit, you feel that they should have immediately offered up the amount of money that you were asking for, and that should have been the end of it. What do you do in that instance where now the defense has made a very serious, substantial offer, and now you want to tell them to go take a hike? You want to tell them, get lost. You want to tell them there's no chance you're settling this case. You want to know the answer? Come join me for a walk through the rain as I head to the train going into work this morning, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You suffered significant harm and injury as a result of a doctor's carelessness. And now, at the very beginning of your case, the defense told your attorney that they would never, ever negotiate. The defense attorney told your lawyer at the very beginning that they feel that your case has no merit whatsoever and that they were going to do everything possible to get your case dismissed before ever reaching trial. And did they do that? Yes, they certainly did. They made motion after motion, meaning that they asked the judge not once but twice on 2 different occasions, once at the very beginning of your case and once toward the end when discovery was completed. They asked the judge to dismiss your case, claiming that your case had no merit whatsoever. Your attorney was able to successfully overcome this request, both of those requests, and now you are heading toward trial. The defense, weighing the risks of going to trial and getting a verdict against them compared to going to trial and winning the case, now have decided, you know what? It's a better business decision for them to start offering money to see if they can negotiate, rather than taking the significant risk of going to trial and facing an unknown. Nobody knows what the outcome is going to be when you go to trial. You could have the best case in the world, and at trial you could lose. That's a fact. You could have a mediocre case, meaning not such a great case, or your damages are not that great. And the jury could disagree and say, you know what? We think you are entitled to receive a very substantial amount of money. In which case, you have literally bought yourself an appeal, meaning that the defense is now going to turn around and do everything possible to appeal that decision, that verdict. So now it's going to continue your litigation for many years afterwards, again with an unknown, with an appeal where you don't know what the outcome is going to be. So now here we are, it's a number of years after you've started your lawsuit. The defense has turned around and said, listen, we understand the risks now. We've assessed and evaluated this case. We've had experts review your case, and we feel it's better for us to try and start negotiating. And we think it's better for you also. This way you have a guaranteed amount of money that you know you have, and that's the end of it. They come back, and now they offer your attorney $2 million. And you turn around and say, absolutely not. I feel my case is worth $10 million. And you now want to go ahead and reject their offer. So the question I have for you is, okay, you reject their offer. What happens next? When your attorney goes back to them and says, thank you, but no, they are going to expect one of 2 things. Either they are going to expect him to come back with a counter offer, which basically says, okay, you offered $2 million, I told you we needed 10. If you settle this case right now, we could do it for $9.5 million, or some other number significantly higher than the $2 million that they offered. In that instance, now they have a choice. Now they have to go back to their principals and discuss the counter offer that you have made to see whether or not this is within the realm of what they think your case is worth. That will generate further conversations usually. The other alternative is you turn around to your attorney and say, listen, I'm not taking any money. I don't want to have any settlement discussions. They are done. I'm done. I want a jury to decide this case. I want 6 members of the community to make a collective decision. And if that means that I may lose my case, fine. If that means that I may get less money than what I'm currently being offered, that's fine. So that's an honest conversation you have to have with your attorney when a substantial settlement offer comes in, because that's part of the risks that you will have to evaluate together with your attorney to see whether it's worthwhile to simply reject an offer outright and not make any counteroffer. Importantly, when your attorney has these settlement conversations, is it important to learn any feedback from the defense while these conversations are going on? And you might be asking, what are you talking about? Well, I will share with you that during settlement conversations, it is extremely important to understand where the defense is coming from. I want to know whether or not the defense has any additional money beyond what they have currently offered. I need to know their rationale and their thinking. They may come back and say, listen, $2 million is our one and only offer. We are not offering another dime. With that statement, now I know exactly where they stand in terms of further settlement negotiations. I know that if you reject that number, they are not going to offer another dime, which means you're going to trial. And you will get your wish to go ahead and have a jury decide your case. On the other hand, if the defense comes back and says, listen, I know your case is worth more, but I've only been authorized to give you $2 million at this point. If we continue these discussions further and I talk to my principals a bit more, I think there's a possibility I could get you X more dollars. That kind of feedback is very useful and very important when having these ongoing settlement discussions. If we get no feedback from the defense attorney, now we are at a disadvantage. The defense is also at a disadvantage because they don't know what type of reaction we would have or what type of answer we would have if they did come back with additional money. They don't know the exact endpoint where we want to be or where we need to be. So in that instance, you're going to have a breakdown in discussions, and now you're going to have a lack of trust. When there is a breakdown in communication, now a lack of trust builds up. Many times, both sides will turn to an impartial judge to see if these discussions can be furthered. Meaning, each side may say, you know what, why don't we have a private settlement conversation known as a mediation, and let's see if we can move past where we are stuck. The mediator, this impartial negotiator, now puts pressure on both sides to try and come to a resolution. Each side compromises a little bit, each side gives up a little bit, and maybe, just maybe, you might get closer, if not to the point where you wish to be, or as close to it as possible, in order to try and resolve your case before going to trial. So as it's starting to rain again, why do I share this information with you? I share it with you just to give you some useful information to help you understand how these medical malpractice cases, these accident cases, and even these wrongful death cases in New York work. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for all the noise here in Great Neck today. I'm Gerry Oginski. Have a wonderful day.